it is, sorry, I'll just attend to that. It is regarded as a foundational project, along with, I think, 21 other foundational projects being undertaken by the CRC this year. It was the result of a successful grant application to the CRC by myself and Dr. Yvonne Haig of Murdoch University. The grant was, the application was made and granted in last year, and we got underway administratively in December, and then began to make substantive academic progress from the 6th of April this year, when Laura Hamblin joined our project. Now, I'd just like to acknowledge the other members as well. Natalie Brown is a PhD graduate of this university, I should say a JD and PhD graduate of this university, and she'll be working on one of the case studies. Lauren Downs is a new PhD candidate starting just in June, and she's also going to be working on a couple of the case studies that I'll refer to by way of conclusion. So there you have the team. I should also mention that we have an invaluable steering committee. I can't remember exactly how many, but it's about 12 people we've got from industry, government and community, from particularly 3 jurisdictions that feature in our project, namely Western Australia, Queensland and Victoria. And the steering committee has important functions in reviewing the stages of our report. There are essentially 3 that I'll be describing briefly, and the final part of the process will be the workshop we hold to review the whole project, or review the whole project report, in early December, with the aim of publishing our full report before Christmas. Now, I should just explain the term regulatory mapping. This is an outline of the relevant law and policy as it is, and we're also attempting to identify questions for future research. We want the report to be an accessible report for industry, community and government, and as well to provide a baseline information for future CRC research projects. One final point to make about terminology, broad terminology here. Note the name of the CRC, Transformations in Mining Economies. And the purpose is to look beyond what has been our traditional or recent focus on ecological rehabilitation, as important as that task is. Thank you, Laura. The next slide. So I'm going to just outline, by way of overview, the presentation for today. Briefly, the project in overview. There are 3 core stages, and we have completed stage 1 in full draft in May, and we've been working on stage 2 since then. The 3 main jurisdictions we're looking at are Western Australia, Queensland and Victoria, but the Victorian stage 2 regulatory mapping we haven't really been able to get to properly yet, and so we'll be making progress on that in August and September. The final report will also include a discussion of relevant Commonwealth law interacting with the state law. The other thing I should acknowledge is that our stage 2 regulatory mapping so far is focusing on the mining and environmental protection legislation, and environmental protection includes the contaminated sites legislation. But we will be integrating eventually discussion, especially of water resources legislation and land use planning legislation, as they relate to mine closure and the transformation in mining economies. Now, on the first part, I'll say a brief little bit and then hand over to Laura. And then Laura will also speak to the focus on stage 2 issues. You can see mine closure planning, financial security, and efficient and effective relinquishment. And then we'll both make some brief comments by way of comparative analysis before we turn to questions. And after our discussion, I'll make some brief concluding comments. So thank you. So Laura, if you'd like to go to the next slide. So here we got the three stages the three stages of our project that I'd like briefly to outline. We begin with key concepts, goals, and institutions. And I note that we've had the feedback and completed a full draft of this report. It's important to begin particularly with key concepts, because what we found was that in beginning this project, there wasn't actually full agreement on exactly what particular words mean. Well, what does closure mean? What does rehabilitation mean? What does relinquishment mean? What does repurposing of mining infrastructure mean? And then, of course, transformation. And I'll flag here that a key issue we've identified, and I think not yet found that we can map much in a regulatory sense, is social transition. So we've identified that issue, but I'll come back to that briefly at the end. So the stage 2, please, Laura. So with stage 2, you can see we're getting into the substance of the regulatory frameworks. We're looking at the state and national frameworks for mine rehabilitation and repurposing. And this is the current focus of our work. I can't say exactly how far down we are, but we've got a bit to finish off, particularly with Victoria and the water and land use legislation. Thank you, Laura. The next point. Stage 3, you can see, is about the experience with the current regulatory framework. So whilst Laura and I have been working particularly on 1 and 2, with some input from Yvonne, Yvonne has the principal carriage of stage 3 because she has the experience in empirical research. So it's the empirical research and analysis of the experience with the current framework. And that draft stage 3 report is due to our steering committee for discussion by the 15th of October. And by that stage, we also hope to have the case studies of the Pilbara in Western Australia, so that particularly the iron ore state agreement regime, the Ensham coal mine in Queensland, and the Latrobe Valley in Victoria. So we put all of those things together by mid-October, and then there's the final reworking of the overall report. And the last point there, I think you can note, Laura, on this slide. So the final report, as I say, our aim is we will do everything we can to achieve this, is to submit our final report for publication by the 24th of December. So it's now over to Laura. Can I just say, Laura's been doing a fabulous job. She hasn't had detailed training in mining law, so she's had a crash course as she's been going along. And she's also an excellent communicator, as I'm sure you'll now see from her presentation. Over to you, Laura.
Thank you so much, Alex. I will also second the previous acknowledgements of the land we're presenting on today and the Whadjuk Noongar people and their elders past, present and emerging. And now I'll start a discussion of some of the substantive material that we've identified so far in this report. So stage 1 is not the focus of the presentation today. Stage 1, as Alex has just said, was mapping the core concepts, goals and institutions. But we'll just briefly review what we discovered in overview there. So we've got the concepts, the goals and aspirations, and the key institutions in the administration of law and policy making. And we identified 3 broad themes across those topics. The first one being the continuing relevance of historical context, namely historical regulatory frameworks. Given the often very long life of a mine, there is a continued need to understand the impact of historical regulatory frameworks and the impact they had on mine closure planning at the time, or the lack thereof. Secondly was the importance of comprehensive transformation, and Alex has briefly flagged this already, in that we definitely noticed the focus of existing institutions on facilitating a more comprehensive idea of what it means to transform a mine after it has ceased operation, particularly considering the social, economic and environmental impacts. Finally, related to that is the evolution of modern legislative intention in terms of balancing both the incentivization of new mining projects with the transition away from certain mining activities and a focus on creating economically and socially viable future uses of that land. In order to best understand some of the content we're going to discuss today, it's important to consider what is traditionally viewed to be the mine life cycle. And we're just going to briefly give an overview of this. This is a diagram that we have been utilising in our report. It continues to be amended. The idea of what the mine life cycle is or should look like is often evolving and is the subject of some discussion. But in general, there are some key steps, including the application for the mining lease and any necessary environmental approvals. Part of that involves mine closure planning and accounting for financial security to be provided. Following this, there is the grant of the mining lease and any of those necessary environmental approvals. We then have the production or operation stage of the mine, which includes ongoing design, planning and construction, including at this stage mine closure planning and any necessary amendments to the initial mine closure plan. There is the cessation of mining operations and the shutdown process, which is ideally followed by final rehabilitation and repurposing, but we also need to acknowledge that there are other ways in which mines can cease operation, including abandonment, being left in care and maintenance, or being divested to a different entity. We then reach the final stage, being relinquishment of tenure and release of any financial security, which is something that we are yet to see a lot of across Australia's mining industry. So before we delve into the content of the mapping of the regulatory framework, I'm just going to briefly overview the structure of stage 2 of the report, which is so far the bulk of the report in terms of the substantive content. So the report aims to address 3 main legal questions using 3 phases of the mine life cycle, being pre-mine operation, predominantly the planning stage, during mine operation, and then post-mine operation and shutdown. And during these stages, we're hoping to address the rights and duties of the industry operators themselves, local communities, including local government, and the authorising authority being state governments usually. So within these stages, we've identified some key issues and some key regulatory focus. The first is mine closure planning, then financial security provisioning, and finally, effective and efficient relinquishment processes and standards. We have then identified 3 broad areas which we believe are going to be further developed across these topics and are also areas with potential for future research. Management and mitigation of residual risks. So we've noticed that in terms of dealing with risks that are likely to require perpetual management, there is a noticeable regulatory gap, and it's something that is rapidly developing, and we'll discuss this further later. Consistent rehabilitation and closure cost estimation. This is particularly relevant, obviously, to financial security provisioning, given that there is a requirement for a level of predictability and consistency, but also greater accuracy in estimating so far ahead of time what is likely to be the rehabilitation and closure costs of a particular site. And finally, balancing hard and soft law to provide that balance between certainty and flexibility. And this is something we'll be discussing in more detail throughout this presentation as well. So to move to the first substantive issue, being mine closure planning. This is a very high level diagram of some of the key elements of mine closure planning in Western Australia and Queensland. There is a requirement for a rehabilitation and closure management plan, which details the actual activities that will be undertaken, and a mine closure schedule, which, as the name suggests, will detail the timeframes that are going to be met. The rehabilitation and closure management plan is generally available for public comment prior to approval being granted, and both elements of the mine closure plan can be amended throughout the mine life cycle prior to cessation of operations. So both Western Australia and Queensland require mine closure plans Western Australia introduced a reform to this requirement in 2012 and Queensland in 2018. And this is integrated as part of the mining tenement approval process. Western Australia has recently introduced a deferred proposal pathway, which allows the lease to be granted before a mine closure plan has been reviewed and approved, but does not allow mining operation to begin. This will be discussed in more detail in the next slide. Queensland has a comprehensive approvals process that involves multiple concurrent authorities, including public interest assessments and environmental impact assessments, alongside the approval required for the mining lease. Both states do require closure plans to be updated. WA has a set requirement for an update at least every 3 years, whereas Queensland operates on more of an as-needed basis. Both states also allow for community comment during the approvals process, but we've noticed that there are limited regulatory requirements for public comment during operational closure, even as mining closure plans are amended. Sorry, there we are. So we'll now turn to a slightly more detailed look at the Western Australian mine closure planning process. Western Australia requires mining lease approval through 2 potential pathways under the Mining Act. The first is the traditional pathway, where a mine closure plan is required to be submitted with the lease application. There is also a requirement for public notification of that mine closure plan through the Department of Mines, Industry Regulation and Safety, and that is an opportunity for public comment and submissions on that plan. The Warden's Court operates in WA to provide a pathway for those public submissions to be considered when there is the hearing to determine whether or not the lease is to be approved. However, there is also the deferred proposal pathway established under the guidelines. Under this pathway, in order for the lease to be granted, the mining tenement proponent needs to submit a mineralisation report demonstrating that there is sufficient mineralisation in the soil to justify a mining operation. However, under the Mining Act, public submissions cannot be in relation to mineralisation content, and therefore this pathway effectively eliminates the opportunity for public comment prior to the granting of this lease. A mine closure plan is still required under this pathway before actual mining operations can begin, but it does not give that same opportunity for public notification or public comment or submission, as the requirement for publication of the mine closure plan only applies prior to approval of that lease. Okay. So Queensland's approval process is somewhat more extensive than Western Australia's. The initial authority is a mining authority approval, and under the Mining Act in Queensland, this requires the removal of any improvements added to the land. Then the environmental authority under the Environment Act requires the progressive rehabilitation and closure plan, which requires public notification and gives an opportunity for public comment and submissions. The Environmental Authority also includes an environmental impact statement process. This process is very clearly detailed within the legislation and has to follow multiple statements, both to set the frames of reference for that process and to allow for an assessment of that statement. There is an opportunity for public comment and submission, as well as a requirement for public notification at multiple stages of that process. Finally, the third limb is under the Sustainable Resource Communities Act, which requires a social impact assessment as well. And this is certainly something that we see leaning towards a sense of comprehensive transformation. There is also a requirement for public notification of that social impact assessment and an opportunity for public comment and submissions. Sorry, just move to our second topic, which is financial security provisioning. So both Queensland and WA are similar in that they require the mining tenement holder to contribute to a pooled fund. Again, WA introduced this requirement in 2012 and Queensland in 2018. Prior to this, there was a system of bonds. Bonds continue to be used for smaller projects and as necessary. It's also important to note that WA legislation has a carve out for state agreements. So where a state agreement is in place, there is an automatic exemption from any existing financial security requirements as set out by that state agreement. And finally, we'll discuss this in more detail for each state, but closure and rehabilitation cost estimation methods remain contentious and each state does this differently. So here we have an overview of some of the comparative points for WA and Queensland. Proponents of small projects are required to lodge a bond before the grant of tenement. This bond may be adjusted over time, and in order to receive that bond back, they must meet their closure obligations. However, proponents of all other projects are required to provide a levy to a pooled fund, calculated broadly based on their rehabilitation liability. The interest on that fund is used to rehabilitate historically abandoned sites, and those proponents must still meet their existing closure and rehabilitation obligations. So if we now look to Western Australia's financial security system, it is a system of pooled fund contribution, either alongside a bond system if deemed necessary, and with the potential for other arrangements to be made through state agreements. However, in general, this is an annual fee. It is recalculated every year. The fee is non-refundable. So the annual fee, because it is based on 1% of the estimated rehabilitation cost at that time, it is considered to be a contribution to the overall rehabilitation costs and is not refundable if that tenement is then divested later or transferred to another mining operator. And again, this contribution does not usurp any existing rehabilitation obligations. This is created as more of a safety net if the mining operator fails to meet their obligations. Queensland, though also having a pooled fund contribution, operates a slightly different system. They have a designated scheme manager who administers the pooled fund. The fee is refundable because it is a lump sum contribution. And so if the tenement is transferred or otherwise taken over by another entity, that fee can be refunded. The estimation of the rehabilitation cost is then multiplied by the prescribed percentage liability of that particular tenement holder to create the contribution value. So the lump sum contribution is required for all high risk projects and at the discretion of the scheme manager. So for our final substantive point, we move on to effective and efficient relinquishment. There has been some academic commentary that this is one of the least developed areas of Australian mine closure regulation, given that a lot of the requirements for relinquishment standards are created through regulations and guidelines during the closure planning process, rather than being blanket statements that are relevant, blanket standards, sorry, that are relevant at closure that a tenement holder can be held to. And an example that's often used is the Canadian system, where they have set standards that everyone is expected to meet. However, as we will discuss later, there are definitely arguments for and against this based on the need for flexibility and tailoring to individual mine sites. So before we delve into this discussion, we need to just make a quick distinction between surrender and relinquishment. So the surrendering of a mine site is a process instigated by the tenement holder or the lessee. In WA and Queensland, it can be whole or partial surrender. It's also important to note that this is not always the case. So in Victoria, there is no option for partial surrender of an area of the tenement. It's either all or nothing. So this occurs at expiry of the tenement or if otherwise instigated by the lessee. Mining rights automatically cease upon the filing of the application for both Queensland and WA. Even if there is a lag in processing time, it is taken to be that the time of filing is when those rights cease. However, any unfulfilled rehabilitation or closure obligations continue. And this is the key difference between surrender and relinquishment. So relinquishment requires approval of the relevant authority. It occurs after the surrender of a tenement and upon review of the closure and rehabilitation activity and obligations. So both WA and Queensland operate on a system of progressive certification, which allows for certain areas of the tenement to be approved for relinquishment at different times. The remaining obligations under mining legislation cease, but it is also important to note that there may be other liabilities that persist. So common law obligations and other legislative requirements can remain. For example, both WA and Queensland have a Contaminated Sites Act. And the Contaminated Sites Act obviously continues to have effect even if the tenement has been relinquished. So for Western Australia, the process to achieve relinquishment begins with surrender. Surrender is instigated by the filing of Form 12. This automatically affects surrender. However, Form 12 only requires details about the tenement and mining expenditure. It does not require detailed reporting of the closure obligations and compliance with the closure plan. However, Western Australia does require the simultaneous filing of Form 5. This can report on expenditure as well as other mining activities and may be relevant to the assessment of closure obligations. There is then a review undertaken of whether or not the mine closure plan has been complied with, as well as whether or not there are any outstanding obligations or monies owing. If there are any outstanding obligations, the tenement holder is then given an opportunity to remedy those and to meet those obligations in order to achieve relinquishment. We now have Queensland's process for achieving relinquishment. It's worth noting that so far, the achievement of relinquishment in both states, but particularly Queensland, has been very piecemeal. Achieving total relinquishment in Queensland for an entire tenement is very rare. And part of this is because it is generally considered, it is generally done through partial areas of the tenement. And additionally, there is perhaps precedent that some industry bodies prefer to keep their sites in care and maintenance so that they can maintain those safety standards and avoid those risks falling back on them later. So in Queensland, the process to achieve relinquishment begins also with surrender, requiring the filing of a Form MMOL 43 to surrender the tenement. Similarly to WA, this form is mostly a formality and does not require any significant reporting or demonstrating of meeting the progressive rehabilitation and closure plan. There is a simultaneous requirement to file an application to surrender the environmental authority with the Department of Environment and Science. This has a stricter requirement to demonstrate meeting the progressive rehabilitation and closure plan. Under the Mining Act, there is no requirement to continue reporting for mining leases. There is a requirement to provide a report for partial surrender, but of a coal mining lease only. There is no requirement for a report upon final surrender. There is a requirement that at the time of surrender, all existing reporting obligations must have been met. So we can see that there are some key differences between Queensland and WA there in terms of when reports are required to be filed and the level of detail provided to different institutions. Queensland in general has a greater number of administrative institutions with more specific delegation of tasks. So we now move on to our comparative analysis. So this focuses on the balance between hard and soft law within the Australian regulatory framework, along with the influence of legislation. We also see the influence of policy and guidelines, industry standards, and the social license to operate. And it has been noted to us by our steering committee that industry and international standards often well outstrip legislative norms. So the balance between hard and soft law is one of consistency, legal enforceability, and predictability, as opposed to nuance, flexibility, and adaptability. We have also heard a lot about the importance of having a regulatory framework which is able to be tailored to individual mine sites, particularly given that the residual risks on each individual site can be unique. And it's very difficult to create a rigid regulatory system which can account for unique circumstances arising so long after the initial approval was granted. However, we've also heard the counter perspective to that, which is the need for a greater level of codification of regulatory standards in order to create a legally enforceable process, particularly in relation to smaller mining companies operating in remote areas who may not be as influenced by things like the social license to operate. We also are lucky enough to have Lauren Downs, the PhD candidate, working with us, who has a great understanding of environmental and social governance frameworks and the impact that things like social license might have, particularly in the future and the development of the regulatory framework. So I will now briefly pass back to Alex for a discussion of some of the key points of comparison that we have identified so far.
Thank you very much, Laura. And you can see by way of the overview that Laura has presented across the two jurisdictions and those three key stages: mine closure planning, financial provisioning, and relinquishment, that the first key difference, and I think we can bring up the next point, please, Laura, is that the regulatory authorities that are involved between the two states is different. So Queensland has multiple purpose-created administrative authorities to oversee the new progressive rehabilitation and closure plan and its environmental impact assessment processes. But even you can see the fact that the Mining Act only really provides for removal of infrastructure or improvements at the mine closure stage. The general provision for rehabilitation is actually under the Environmental Protection Act, and therefore administered, I think it's by the Department of Environment and Science. And then the recent reforms have introduced new officers, particularly I think it's the Rehabilitation Commissioner. So it's quite notable that there are different agencies and different legislation involved in Queensland from Western Australia. In Western Australia, the role generally is dominated by the Department of Mines, Industry Regulation and Safety, or DMIRS. Now, there is one extra point to note with, and if you can bring up the next point, please, Laura. The Western Australia does, of course, have a role of the EPA, the Environmental Protection Authority, with the environmental impact assessment. And across the late 90s and early 2000s, there was considerable litigation and reform about the role, particularly of EIA, and that is environmental impact assessment by the EPA. And the legal requirement was clarified as a mining lease application that could have a significant effect on the environment should be referred to the EPA for assessment before the grant of the tenement. And the Mining Act was amended then in 2004 to introduce this deferred proposal pathway. And that has transformed the regulatory roles in ways that we suggest is questionable. Now, of course, that may be a contentious view. Clearly, the reforms were preferred by the industry and acceded to by government and parliament. But it does, as Laura's pointed out to you, it does make a difference between the transparency of the system. The other point just to of course note is that those mines that are operated under state agreements, and the classic examples of the big iron ore mines in the Pilbara, they are not subject to the same level of regulation, but it is, of course, the role of the EPA to review mine closure plans for state agreement mines. So the second point, please, Laura. So the other key difference that we really noticed is in the statutory definition of the process. And although we've not spoken much about the Victorian legislation, I can say from my early perusal of it, both the Queensland and Victorian legislation are much more prescriptive of the core procedures and decision-making powers. If we move to the West Australian point, Western Australia does have stricter reporting requirements. So for example, the annual reporting, as well as the statutory mandated 3-year review of mine closure plans. But otherwise, the mine closure system, indeed the mine closure planning system and the mine closure system, are dealt with under what are called statutory guidelines. So they're guidelines that are required to be endorsed by the prescribed official, I think it's the state mining engineer or the CEO, and then must be published. So they are public documents, but there's a significant point about what is the legal enforceability of guidelines as opposed to statutory provisions. And we've had some interesting early discussions about that point with the steering committee. And the next and final point is about the transparency of closure outcomes. So Laura's noticed that the following approval of the mining tenement, reporting for Western Australia and Queensland remains confidential for a minimum of 5 years. That is a reporting of the that's the annual report, I think. And this means that although the public
the data as well.
Of the data as well. So this means that although the public can get access to the closure plan provided at the application stage or post-grant and the approval of operation stage, that document has to be reviewed every 3 years, may well be changed, and there's not, it seems, the public transparency with the exact current state of the closure plans. One final point here, and this is by way of an international comparison. Some of you may have heard of the case of Bear Creek Mining Corporation and the Republic of Peru, and I'm indebted to Lauren Downs for drawing this case to our attention. The point about the Bear Creek mining case is that Bear Creek Mining was a Canadian company that acquired in a slightly unusual fashion the rights to explore for silver in the border areas of Peru. And they did this through an employee, a Peruvian employee of the company. That was not permitted by law, but eventually the government of Peru did endorse the grant of the mining rights to the company. It then found some silver, but when it wished to proceed to production, there was a very strong local community, including Indigenous community, backlash against the mining proposals. And that was sustained over a period of time, notwithstanding that the government of Peru actually endorsed what the company was doing and granted the relevant tenement. Eventually, however, the political backlash was so strong that the government withdrew the mining rights that had been granted to Bear Creek Mining Corporation. So the corporation began arbitral proceedings under the investment agreement between Canada and Peru, and was successful in gaining a finding that it had been improperly, under the terms of the treaty, had its mining rights revoked, and it did gain an award of sunk costs by way of compensation for the removal of those mining rights. However, it's interesting particularly that the social license to operate concept was important here in the reasoning and the award. And at least one member of the arbitral tribunal found that the company should have paid greater attention to the social license to operate, should have engaged better with the local community to try and inform them and consult them about the proposed mining. And this was a reason for not awarding a higher level of compensation. So that finishes our presentation. If we can go to the next slide, we're happy to take your questions, and then I'll finish up very briefly with some final comments. Please direct your questions, certainly at least to Laura, and I'm happy to chip in as well.
Thanks, Alex and Laura, very much for that presentation. I've got a few questions coming through the chat, so I'll just read those out to you if that's okay. So firstly, how do you think that the rehabilitation of projects operating under existing WA state agreements will be achieved when mining operations at these long-running projects cease? You're able to comment on that?
Absolutely. This is something that we've definitely discussed with our steering committee. We note that the use of state agreements is dwindling. And as Alex mentioned, it has much more been a thing used for large projects, particularly in the Pilbara. In terms of how these projects are going to be rehabilitated, particularly where standards of closure and rehabilitation have significantly evolved since those state agreements were brought into place, what we have come to understand is that this is a key area of impact for soft law and for areas of environmental and social governance, in that existing industry and international standards and norms, particularly for these big companies, will be very influential and usually will hold the companies, effectively speaking, to higher standards than existing regulatory requirements. So it is expected that in order to maintain their social license to operate, it will become an expectation of their corporate social responsibility to rehabilitate those mine sites. However, there is a notable gap of legally enforceable requirements, and it does depend on each individual agreement. Alex, I'm not sure if there's anything particularly you wanted to add to that.
I'll just add that the Environmental Protection Authority is emerging as the key agency for reviewing the closure plans under these state agreements. And there is, of course, a statutory framework for environmental impact assessment, and some of these mines will have been approved before that regime was in operation, but it seems as though there's an agreement, or there's an acceptance by the companies that their closure planning will be reviewed by the Environmental Protection Authority.
Great, thank you. And I know you've mentioned the jurisdictions of Queensland, obviously Western Australia, and then also Victoria. Will your research be considering the regulation of mine closure in New South Wales or potentially any other jurisdictions?
So let me answer that first, Laura. So the plain answer is no. Initially, our idea was that it would be a national survey, but probably with not a lot of attention to New South Wales. And that actually just goes to the design of the CRC and the bodies that are involved with it. But we've found that the task, even of the effective regulatory mapping for Western Australia, Queensland and Victoria, is sufficient to occupy most of our attention. So although there'll certainly be some reference to particular ideas or perhaps particular cases, including in New South Wales, I mean, there are cases in New South Wales for the Land Environment Court that address mine closure planning. So that can be brought in, but the main part of the report will focus on the 3 jurisdictions we've named, plus the interaction with Commonwealth legislation.
Great. And then, so I've got another question here. Will your report consider any further comparison on residual risk processes, noting that Queensland's new system in that regard is very comprehensive?
Absolutely. So Queensland's process is rapidly developing, and their residual risk framework is certainly leading the way for Australia. And the framework at the moment is provisional. They have issued some provisional guidelines, which, as the name would suggest, are likely to be reworked continually. However, the influence of the Rehabilitation Commissioner as well, in conjunction with this residual risk framework, is a fantastic comparison point with WA, who are yet to really address the significance of residual risks as opposed to other risks that occur at closure. And that is definitely something that stage 2 of the report is going to look at in detail. Additionally, it's another thing that has been drawn to our attention in terms of international comparisons and the need for creating a predictable way of assessing residual risk liability and attributing that liability. It's also been one of the motivators within WA for particularly larger companies to be reluctant to have full surrender or relinquishment of their tenements because of the inherently unpredictable nature of some of those residual risks. In order to best account for any potential liability, it remains very beneficial for that company to maintain some sort of license over that land. And I know that Alex and I are going to be looking at a slight discussion in terms of pointing future research in the direction of considering things like post-production licenses and other sort of suggested mechanisms for addressing that residual risk.
Excellent. I can't add to that.
I've got a question here from Simon Molesworth. Firstly, he says that this has been an excellent presentation, and I share Simon's thoughts there. So the question is there any Australian jurisdiction which effectively deals with legacy mine degradation left over from distant pre-regulatory times? And he asks, having had experience of an inadequate New South Wales regulatory response to this issue, namely his family's Far West in North New South Wales sheep station, which has 45 legacy mine shafts, largely uncapped.
Yeah, so this is definitely a big issue for the regulatory framework, and one of the reasons why the financial security provisions are such a hot topic. The existing financial security provisions are supposed to be designed to allow the government to use the interest accumulated on that fund to specifically rehabilitate abandoned and legacy mine sites like this. We can't speak specifically to New South Wales at the moment because we haven't delved into that as an area of research. But definitely that is part of the legislative intention. Given the recency of the operation of the pooled fund and many of the issues, many of the co-regulatory issues that arise when the state government's actually looking to conduct that rehabilitatory work on those abandoned sites, I think we're yet to see how effective that's going to be in practice, and there's definitely discourse on both sides. So there are those who feel that this system of financial security is well overdue and will provide that opportunity for the state government, and there are also absolutely those who feel that it's actually going to be a disincentive and create even less effective rehabilitation of those legacy sites. So I think it's definitely something that the government is looking to achieve, but whether or not that will actually be successful remains to be seen.
Can I just add very briefly to that? It'd certainly be part of future research to look at how these pooled funds, which in Queensland and Western Australia are intended to address the abandoned sites. We've not yet had the chance to look at how that may be operating in fact. And Simon, I think I briefly note that if your farm were in Victoria, it may still have a fairly high chance of abandoned mine sites. But our knowledge so far is that Victoria doesn't have a pooled fund system. So it'd be interesting to know how Victoria would propose to address its plethora of abandoned mine sites.
Great. So the next question is, do you feel that the Latrobe Valley Regional Rehabilitation Strategy is likely to be influential on the rehabilitation plans for the brown coal mines in Victoria? And if possible, could you speak to any analysis you've done on the interaction of the general environmental duty in the Environmental Protection Act 2017 of Victoria with mine site rehabilitation obligations in the MR (SD) Act of 1990? So I'm not exactly sure which.
So the Mineral Resources Sustainable Development Act 1990 of Victoria. So Bronya, they're excellent questions. Laura may wish to say something about this, but so far, whilst I think we have identified those issues, we haven't yet had the chance to explore them. I believe that the new environmental duty will be of particular interest. The role of the strategy, I think it's a planning strategy, and I think it relates to the land use legislation. And so that particularly will be of interest in the coming 2 months. So I hope that these chat questions are going to be well recorded for us, so that we've got a very good reference for what we need to attend to.
Yes.
Yeah, I will also just briefly say to that the Latrobe Valley strategy is one of the reasons that Victoria has been selected as one of our jurisdictions, in that it offers a great comparison point with sort of bigger resources states like WA and Queensland for how regulation might be introduced that does effectively deal with specific examples and specific mine sites, and how that can then be applied across the state as well as a standard.
Great. I think we've got time for one last question, and I will pose Andrew Mack's question because I think it is one that I had on my mind, which is, has any work been done or will it be done in relation to the success or otherwise of the various regimes in delivering closure / relinquishment outcomes?
So Laura, if you start on that and then I'll add.
Yeah, no problem. So certainly that will be something we're looking to in the third stage of the report, and something Yvonne will be looking to in conducting her empirical research. We are trying to be careful to limit the report to focus only on mapping the regulatory framework and not necessarily making any conclusions about its efficacy. However, with that said, given the research of stage 3, that will necessarily be something that we consider in summing up at the end of the report. And it's also something we'll be considering in a discussion of any of the academic discourse on the matter. A lot of the current regulatory framework is relatively new in terms of comparative to the length of a mine life cycle. And so a lot of it is yet to be seen whether or not it creates effective outcomes. But that is definitely something that will be a focus of stage 3. Alex, I'm not sure if you wanted to add to that.
Oh, look, only briefly, you've said pretty much what I was going to say, Laura. The only point I think I'd add is that to make an effective analysis of the operation of the regimes in achieving, that is, delivering the closure and relinquishment outcomes, it's probably going to be, require the scale of research of a new 3-year project, which I'm going to refer to just by way of conclusion.
Great. All right. Well, did you want to do your concluding remarks now, Alex?
If you're happy for me to do that. So,
Alex, I might just mention quickly, jump in there before you conclude, just to say that anyone who sent me a private question as well, and some of the remaining questions, I will be happy to save those and respond via email later as well, given that we have run out of time.
Thanks, Laura.
Thank you, Laura. So just to reiterate then that the stage 3 empirical work is underway with the preparation of the 3 case studies for Western Australia, Queensland and Victoria. And I note again that Natalie Brown was looking at the WA one and Lauren Downs at the Queensland and Victoria case studies. The aim is to have all of this basic research done by October, and then pull together the full report with the steering committee in early December. The point that we've particularly noted so far, and I think we're indebted to particularly some Queensland officers for drawing this to our attention, is that the legislation deals relatively well with much of what we've been looking at. That is, there is legislation about it. There are gaps, there's room for further research, but it's particularly when you come to the social transition, it seems like there really isn't much regulation there. So we've been met with questions about, well, what about occupational health and safety? What about the planning for the economic futures of these communities? The social impact of closing mines, perhaps even in a region. And the best we can say so far is there really isn't a lot of legislation about that. or other regulatory instruments. And so that's going to be a very key part that we'll be needing to look at. The CRC has just recently released its research prioritisation plan. I don't think it's yet generally public, but it will be calling for applications for research projects for the next 3 years. And if anyone's interested to join our application attempts, please do not hesitate to get in contact with us. As you can see, Laura and myself, Yvonne, Lauren, Natalie, we're all based in Western Australia, and we're particularly looking for excellent researchers to join us, especially from Queensland and Victoria, but not only from those jurisdictions. So that's looking to the future. We will be making the next stage application in the coming months, and I think the CRC is hoping that this report will provide a good baseline both for community engagement, industry engagement, and government, as well as the foundations for all of the future research projects. A special thanks to Laura. Laura has had the privilege of working 5 days a week on this research. I'm limited to about 1 or 2 or so. So I'm really grateful for the way she's pulled this material together and made an excellent presentation. And thanks to NELA for the chance to do this presentation.
Yeah, thank you so much, Alex, and obviously to NELA for the opportunity to present.
Great, thanks so much, Laura and Alex. I'm really looking forward to reading the report once it's released, and if there's any updates that NELA can give its members in that regard, we certainly will. So yeah, thanks very much, and yeah, I'll conclude this webinar now. Thank you.
Thanks, everybody.
Thanks so much.